1501.
Yes.
Appeals are accordingly allowed, setting aside the improved order dated 5/3/2024 passed by the High Court of Karnataka at Bangalore, as well as the order dated 12/12/23 passed by the Learned JMFC, 5th Court, Bangalore. Learned Judicial Magistrate First Class, 5th Court, Bangalore shall entertain and expeditiously adjudicate the complete cases filed by the appellant in accordance with law. Grateful.
The appeal is allowed, the impugned order dated which last act so is hereby set aside, and the proceedings initiated under the charge memos bearing number so and so issued by Principal General Manager Bangalore are held to be validly initiated.
Item number 801.
801, 7th August.
Please, madam.
7th August.
Item number 802.
23rd September.
Item number
Very
802.
early date it was.
Can't give you an earlier date.
Light of the petitioner lot.
Can't give you an earlier date. We've already given dates in other matters.
23rd September.
23rd September.
Item number 803.
7th October.
Not
No earlier date is possible.
Item
7th October.
804.
should be matter was listed again and again but deleted. So kindly matter may be listed on 20.
Public will give their attention.
12th August is already 21. Tentative date.
Yeah, send that. Not to-
Not to be deleted.
Item number 805.
Almost undergone around 10 years.
Could be. That's not how we-
Your Lordship, the only difficulty is that right now I am out on payroll, which I have to surrender on 4th of August.
That is not.
My mother is suffering from serious ailments, Your Honor.
It's okay. We'll give you a date.
Item number 1.
My lord's permission, my lord, may I mention one matter, my lord. It's listed on Monday, item 37 before my lords. But there's a similar matter coming, my lords. Just
What do you want?
my lords, tagging of that matter. My lords, SLP has been numbered, it's of the caveat.
We don't know whether it will be allotted to this court or not. It's a
Yes,
first
ma'am. So it's a common judgment.
common judge.
Common judgment. Now, this is the tagged matter.
There's already an order tagging it.
There is no, my lords.
Only status of the case.
This is the matter, my lord, which needs to be tagged. Therefore, and
This
this
has not come up till now.
it's my lords, SLP has been numbered, a date is not coming.
It has not been.
No, my lords. And Monday, this matter is there, my lords, item 37.
You can argue the matter when the
Because item
matter
30,
comes.
clients are also on.
Common judgment. Then
Because advocates are coming, my lord, that's the only difficulty, my lord.
they can argue without the matter being there. It's the same common judgment.
It is, my lord, my lord. Some
Yeah,
because there's other seniors also, my
We
lord.
can direct the matter to be listed along with that matter when we don't know whether it's going to be tagged with this. One.
It is, my lord, it's common judgment, my lord. So common judgment.
No, Mr. Alias. Ask the advocates to come and argue that.
Right, great.
Lordship's kind of permission, may I mention item 68 on Lordship's board for the
No mention for an adjournment, please. We can wait till the matter is.
very good.
Item number 1.
Please.
May it please, my lords, I'm appearing for this state.
Not file the documents as directed.
My lords, may I submit, my lords? We have
Yeah,
filed the
everyone
call
has to
data
be filed.
records, my lords, yesterday.
It was
Yeah.
filed yesterday.
Please,
I am
my-
not missing.
Please, my lords, we have served it on the other side. However, I would like to
When
just submit one thing. my lords, with my lords' kind
Anyhow, it's
permission.
not been placed before us. Please see that it's
I
served
have
on
also
both the
not-
learned counsel appearing again.
I've not received.
Maybe go and learned counsel appearing for the state of UP shall ensure that the earlier order dated 14/7/2025 is complied with by serving advance copies on the council opposite and ensuring that the matter is placed before us by the next date. The affidavit and material is placed before us by the next date.
I use.
Tom. You take
Wait.
out
Please.
the bill manual.
Only for
For what reason?
To the guidance of the Advisory Council.
Adjournment to sort on the ground
Lordship next.
ill health of the learned arguing based on September.
I was not I was
You
not.
were a co-driver accordingly,
My lord, I was not-
and you would not know what is being carried.
Not the conscious possession of this drug, my lord.
200 kgs of ganja, you can't even smell it. How can you claim?
It was even not a co-driver, man. Also, there is no forward back. Linkage regarding the evidence, my lord. No money transaction has been alleged, my lord.
We find no good ground and reason to interfere with the appeal judgment, especially.
Item number 5.
Serve the standing counsel for the state, please. And counsel for the petitioner is permitted to effect service of notice upon the designated of the standing counsel of the state of Rajasthan. List on 6th August.
Item number 6.
Lords, I'm appearing for the
Service is complete
petitioner.
here. You are appealing for the state?
I appeal for the state, Your Lordship. We're seeking some.
Trying to file a counsel. There's an interim bail is already.
Lords.
Counsel appearing for the state of Bihar seeks some time to file a.
Lordships can have it on the next time.
We'll give you some time. There's no point in giving you a short date and you asking for it. List on 7th August.
Great.
Item number 7.
Lord, I'm appealing for the petitioner, Lordship. The allegation is leveled against the petitioner is, Lord, under section 317, subsection
Counter is filed.
245. Yes, Lord. Counter is filed. Pleadings are completed, Lordship.
Stolen property. What is the heinous offense that you are saying that he has committed?
This is the racket which is involved in the cyber fraud instruction. They were involved in getting open the.
What is the stage of the investigation?
Charge
The charge sheet has been filed, my Lord.
It have been framed, my lords. Now it is at the stage of.
Charges are framed and void.
Material prosecution witnesses may be examined. I will next the statement.
He is supposed to have dealt with stolen property. Most of the provisions of 317 BNS.
My lords.
Yes,
Then
Lords, if I may request, my lords, just the.
he's not done anything. He's dealt with the stolen property.
No,
According to you,
I
he's
have
indulging in some
statements of the
cyber fraud.
like the statements of the witnesses with my counter affidavit, it states that he is very instrumental in getting open the bank accounts and then selling it further for cyber fraud matters. If I may, my lords, be allowed to show.
But what is the purpose served in keeping him in prison? In a
My lords,
matter of
He's
five material witnesses may be examined, my lords, then my lords may again consider.
trial has started now.
Charges have been framed.
Trial has not started.
It will get
How
started.
many witnesses are there?
My lords, in total, my lords,
Lord,
have to check.
with due respect,
Let us
may I
start
submit,
with
Lord?
Yes.
Lord, the petitioner is a boy aged about 20 years, Lord. He's in jail since 8th of February, my Lord. And there is no criminal antecedent against him, my Lord.
The petitioner registered counter affidavit having been filed. We are not inclined to accept the plea of the state that the continued incarceration of the petitioner is warranted at this stage. It is an admitted fact that the charges have already been framed and the trial is yet to commence. The petitioner has been in prison since 8 February 2025, 8 2020. Continued incarceration. The custodial interrogation of the petitioner will not be warranted or necessary at this stage. The petitioner is occurring thereof, granting allowed, the petitioner shall be released on bail in connection with the dismissal on terms and conditions to be
My lords, in total,
Highly
there are
obliged.
13 prosecuted.
I'm
Let
obliged.
him be released.
Item
Obliged.
number 8.
May I please, your lordship? Lord, in an appeal by a Lord suspended director, your lordships were pleased to pass this following interim order, my lord, page 34 and 35. Subsequently, your lordship was pleased to dismiss the appeal because of non-compliance. But my lord, these observations are there at page 35.
You are appearing for the
For the
RP.
RP, Lord.
For the
For the
RP.
RP,
It only says basic amenity shall be provided to those who are in use and occupation.
exactly. It's very, very
If they
clear.
are in occupation,
And
provide
here,
them.
here
They're
my lord,
not in occupation.
that's right.
They're
But here we're not taking mischievously what is being taken advantage of. We're not taking today none the completion
You
certificate.
say that occupation certificate is
is
not there.
not there.
But without that, if they've been provided.
There cannot be. There is not.
I do not know if there's any evidence of possession having been given, you can't deny.
Just this clarification, my lord, police complaints are being filed against me, and my lord, application.
You verify whether they have any document in proof of possession being delivered.
Yes.
If possession
Without
is delivered,
your lordship is
the
absolutely.
RP was present when we passed this order. At that point of time, he never said anything about possession not being delivered to anybody.
Or that day, my lord, RP did not have the documents. And
The resolution professional appears through video conferencing and states that he is not being permitted to enter into the premises.
But
that is all that he said.
There are.
Whereas the counsel who appeared for these people
Yes.
pointed out to us that they are in occupation and they're not being provided basic amenities.
Lord,
That is the reason why this concluding paragraph.
Lordship, I kindly see the enclats judgment, my lord, at page.
Whatever it is, if there are people who are staying there,
Nobody is staying there.
if they're not there, you need to verify whether they
Just
have
this
documents and proof of possession. There's no need to clarify it. If they file a contempt case, we will ask them to show proof of possession.
Because
If they show
your
proof
lordship
of
is right.
possession, you have to give them a basic amenity.
Because we not without occupation certificate, there can't be a lease.
That is neither here nor there.
Without lease,
If
there can't be an
If
opposition.
the other side has put them in possession without an occupation certificate.
It has not been. Actually, it has not.
Verify then. You verify whether they have any document. If
They have
anybody is
verified,
staying
not,
there,
they have not been.
if anybody has occupied the
Yes.
premises, ask them for proof of possession being delivered.
Yes.
If that proof is there, then you're bound by this.
Not what they are doing.
If they have no proof of possession being delivered and they have illegally occupied the premises, then you don't have to.
That is all. That is the clarification.
That is, we don't need to clarify that. That is implicit in the order.
Not the misuse of your lordship's order.
You have to verify the documentation and take necessary steps. We don't need to clarify this.
But actually, we were permitted inside the project.
The order dated 21/10/2024, which was passed in the presence of the resolution professional who was appearing through video conferencing. The order speaks for itself and needs no further clarification or explanation. The MA is accordingly dismissed. Why is it kept at, there's a delay in filing it?
Yes.
Say delay is been delay.
Item number 9.
Item 9, I seek to withdraw this in terms of the compromise clause. I placed on record.
Withdrawal. All three courts are against you.
E8 is the compromise clause. Subsequently, you settled with the other side. E8 additional document. You wish to withdraw it in this record? In terms of the compromise hearing for the petitioners states that he is instructed to withdraw this special leave petition owing to the out of court settlement arrived at by and between the parties. According to the said statement, the special leave petition is dismissed as withdrawn.
Item number 10 along with 52.
This we have to. Unfortunate situation here is nobody seems to understand basic procedures.
Maybe it's my fault. I will only pray the.
No, one person files against the main. I specifically gave you liberty to include a channel. Include, meaning to say that you will amend the prayer in this and file it in this case itself.
May I pray that
And there were two petitioners before the High Court. One files SLP separately, the other files one other SLP. In both the SLPs, the other petitioner is completely omitted. We don't know how the Supreme Court is registry is permitting this kind of.
Lordship, there may I clarify. Both
Counsel,
SLPs are filed against separate orders in the writ petition, separate writ petition numbers.
These SLPs as they stand are liable to be dismissed. We gave you liberty to include a challenge. Even then you don't understand what you need to
I'm
do.
sorry.
We are not going to teach you first principles now.
I'm sorry, Your Honor. May I just.
And look at this other thing. How do you change the cost title? Once the writ petition was filed by two people, both should either be shown as petitioners in the SLP, or if one is not joining, he has to be shown as a pro forma respondent. You can't completely omit him from the array of parties. What is this?
Your Honor, there may I submit. The High Court specifically, by an order, specifically allowed withdrawal of the petition, petition number 1.
Then how is it that one SLP is filed by one petitioner, the other SLP is filed by the other?
I will place that order on record.
No, if you say that one petitioner withdrew from the writ petition, how is it that both the writ petitioners are before us by way of separate SLPs?
No, Your Honor, now may I just explain? In the first matter,
We are just wasting time with this matter now. My brother has a special bench in the afternoon, and we don't really have time.
I will only pray that the other matters which are listed.
Please think over what you're doing and take it up on Monday, next Monday. Both the matters will be dismissed if you do not take necessary.
Your Honor, may I just make
Based on
submission?
Monday, give the date. Learned counsel for the petitioners appearing in both the matters. Learned counsel appearing for the petitioner in both the matters.
Your Honor, may I
Shall
take
take
short
steps
in
to
place?
rectify
Can it be
the
Monday
mistakes
week?
that have been pointed out.
Can it be Monday week, Your Lordship?
Monday week. Monday week. But do something, please. Otherwise, we'll dismiss both of them.
Item number 11.
One of the joint mortgagees sells the property, keeps the money with him.
Mr. Narendra Sethi, how is the company responsible if the TFC does not pay you the amount? Having collected the amount in 95, 96, you are not paid till 99. And you keep quiet.
No, my lord,
You had to pursue it with the PSC. There is a question of holding the company responsible and saying that my interest will keep on mounting.
only one submission, and I will not press it beyond it. But the PFC was also a defendant, but the decree could have been only in the.
Both of you took joint possession. You knew exactly what was happening. Both of you had pari passu charge over it. No question. No good ground and reason to interfere with the influence judgment.
On a completely different point,
Especially
an amount of 12 lakh rupees that was payable to me was missed by the High Court. Lordships grants, but I can show it to your Lordships in a minute.
That we filed an application.
Your Lordships may just indicate that, since I'm making a claim that 12 lakh amounts was missed by the High Court, I may make an application.
Senior counsel appearing for the petition states that the
11
order
lakh.
passed by the High Court did not take into account certain amounts which were due and payable to the petition.
Payable by
If that be
company.
By you. 11 lakhs.
If that be so,
It has never
open to the
come on record.
petitioner.
It is
It has
there.
nowhere come on record.
So far as that aspect is concerned, in accordance with.
Yes.
But the whole money is paid, it has nowhere come on record earlier.
This 7 lakh, is it?
No, it is there,
No.
but it is there before the appellate court. What the court did is, On the date of the sale, it took into account the amount due as on the date.
Don't say that also, just say that in the event the petitioner has any grievance with regard to any amount not covered by the
That's fair.
order passed by the High Court, would be open to it to take appropriate measures in accordance with law.
Great. All right.
Item number 12.
Please.
12, I just want to make,
Mr.
before I
Shamdeo,
state the question of law.
this is unfortunately for your client, it has come back to us. This
No, it's
has
good.
gone through a long process.
It has.
This is completely bereft of bona fides. Mr. Nakul Diwan appeared in the earlier matter.
No, that was for someone who's against me, Manoj. That was.
We are not going to interfere with the CIRP process at
But
the
can I
behest
just-
of a shareholder.
Should I just make 2 points? The first is,
And that too, you are seeking recall of an order passed in October 2024.
so I'll just state the point. I'll just first state the point, which has nothing to do with the merits. That this order,
How many shareholders are there? One after the other will be
No, I'll just indicate. I'll come to that in a moment. But first point I want to make is that this order of 7th March 2025 was challenged by me in a writ petition. I can mention that because the impugned order here was challenged in a writ petition before the Karnataka High Court. I secured a stay, which is at page 231 of the paper. That matter is coming up before, presumably, your lordships on the 29th of July in an SLP filed by the other side. That order is annexed.
Then why are you again filing an application for recall?
Yeah, so that writ petition is pending. So no, I'm just stating the point.
But this barking up two trees at the same time.
Yeah, it's barking up
multiple indicative of lack of bona fides.
It does.
One way or the other, the CD and the people set up by the CD are trying to stall the CIR.
All right, so
That
then
is clear on the face of it.
all right, fair enough. So
In spite of our order that the CIRP will go on, notwithstanding that injunction order granted by the trial court, every effort is being made to see that the CIRP remains stalled.
Even
Okay,
after
can I
your
just-
lordship's last
can I
order,
just make-
a fresh suit has been filed in Bangalore by a lessee now. After your lordship's order.
okay, now Milord, may I just but that's a common enemy that we have.
We are
Can
not
I just mention one
going to
point?
spend any more time on this.
Grateful.
Very good, grateful.
And no good reason to interfere with the impugned judgment and order passed by the NCLAT. The appeal is accordingly dismissed.
Grateful.
Item number 13.
Wait, please. No, since 1971.
Mr. Sudhanshu.
Yes, sir.
This 1985 suit filed by the petitioners.
Look, we have
was
filed an
against
appeal.
whom?
Appeal is pending.
It was filed against whom though?
Those are other people.
Some other people.
Not
There's a finding that you're not in possession.
I am in possession, and that's what they say in that suit, that my predecessor was in possession as a tenant. And this Salarjung is complete fraud. Salarjung was the Prime Minister of
Finding that in the suit that you're not in possession.
No, it says that my predecessor was a tenant.
No, but the High Court record.
High Court is incorrect on the point. I got the judgment of the.
Is there any finding delivered by anyone to the effect that you're not in possession?
Yes. No, in fact, it says that
The trial court. They went filed suit for declaration of ownership and
That is the 1985.
yes, which is decided in 2010, decided against it. They filed an appeal is dismissed.
He was not the party then. Whether my friend
But
was
is there a finding that you're not in possession?
No,
Be
it
fair.
says that my predecessor was a tenant in the property. In fact, he's the owner, and that's what I have.
Then if a 44-year delay issue, we need to look into.
Yes.
A revision can't be entertained.
At his instance, 4 courts below
Revision.
have
Onward. Even if a revision can get any, you just
I'm
party. Say that
party.
in the writ petition, I'm responding.
that 1958 that I can't go. Imagine the
So limited to the
All
petitioner.
of Aurangabad is claimed.
Please look at the petitioner only.
Yeah, we'll
Only the petitioner.
Whoever is on caveat, give your names for whichever
We
respondent
will.
accept notice on behalf of respondent number.
They should have filed the decree of the suit.
and wait for the notice. This correctly need not be served on the respondents. We shall be effective on the representative respondents by all that, including this thing. We'll give you a longer date, but file your whatever decree you have in that 1958 soon.
I'll also
let us see that also. 9th September.
But may I request for stay?
Stay of what?
You know, in the impugn judgment, will
There's only a mutation.
Status quo, then
If you're in possession, then
status quo, your lordship,
status quo is
I'm going to submit us
If
to
you're in
respond.
possession, then
They are not, please see, Lord.
if they're not in possession, you are in possession. State.
Lord, but that point has
That
been
indicates that you are not in possession.
Lord, the courts have said it is subject to
Status
doubt.
quo obtaining as on today shall be maintained in all respects with regard to this.
They are not in possession, is the finding of the
Whoever is
civil,
in possession
is the finding of the civil court.
If you are in possession, why are you protesting?
Your lordship was.
Because you are obviously
The
not
civil
in
court
possession.
finding, they don't place the judgment on record.
If you're not in possession, you would
Appeal is
protest.
dismissed.
Counsel, the more you speak, the more it negates your claim of being in possession.
I am so bad.
That is.
My lord,
Permit us to respond before your lordship takes up the interim.
We've only directed status quo. Whoever is in possession, remain there.
Grateful.
Number 14.
My lord, I'm paying for what we, my lord.
Only 1981.
My lord, my lord, give me 1 week, my
You
lord.
tested the award.
I will.
You filed a reference.
Today, I am not, my lord, otherwise, my lord, kindly on top of that, then give me one opportunity, my lord, 39, my lord,
Long litigation
my
that
lord,
proceeded.
till today, my lord,
This
petition is with,
filed under Article 32 of the Constitution in relation to an acquisition dating back to the year 1981. We are not inclined to entertain this writ petition. The writ petition.
then my lord,
Dismissed
permit me
at
to
the
file a
threshold.
curative petition.
No. Curative petition, it is not for us to permit you. There is a procedure to be followed.
My lord, it was not allowed for petition, my lord, it was, my lord,
Next
legal
matter.
petition.
Number 15.
That's also.
15.
Yes. 2 points, my lord, 2 points.
Their mutation was earlier in point of time.
One mutation.
How can you claim ignorance till
Yes, ma'am.
2014?
May I just make sure 2 points? There is 2 clause in that very submission files. 2 clause. May I permit me to make
Once you know about the fact that they had their mutation earlier in point of time,
show that
there's no question of your claiming ignorance of the state.
they may show from the
No
very
question
finding.
of sustaining your suit.
Page 11 from very finding I would be able to show. Permit me 2 minutes. One of my just my mutation entry number is 5516. Their mutation number is 5586. That is one. My mutation entry,
Their
5516.
mutation was on.
88 they claim. A minute, ma'am.
There is a question of claiming. We are not going to go into factual.
No, I'm not. They say that 5586 made in 1886.
18488 is there. Yours is 15th December 88.
No, mine is 9192.
9192, even worse.
So, a minute, madam.
Sorry,
I won't. Just 2 minutes.
for even
2 minutes. Once I just show flow from
not a case for wasting even 1 minute.
a minute, madam. I will not take.
We find no good ground and reason to interfere with the.
Because my land has been grabbed, madam, completely. If it's a report be
Passed by the High Court, especially questions according to this.
Well,
Want to challenge a sale deed of 1981 now? In 2015.
may I just satisfy only 1 point.
There is
Number 16.
no question.
Will not permit a point.
On the face of it, the dates are completely against you. There's no getting over them.
Allow me to say that they are in my favor. Allow me to make one submission.
The very fact that you filed a suit in 2015 to challenge a 1981 sale deed, that seals your fate.
Allow me to show that dates are in my favor. A minute,
Which state is in your favor? Did you or did you not file the suit in 2015?
That's right, Madam.
Are you challenging a sale deed of 1981?
That's right.
There ends the matter. There ends.
May I just show that was fraud, my lord?
There ends the matter.
My name was
It's
there.
a registered document. No question of your claiming ignorance.
My claim of fraud, my lord.
Sorry, Council. We've spent enough time on this. Item 16. Pledge. This matter will have to Mr. Gopal Shankar Narayan. I don't hear matters of companies or even the SBI in which I hold shares.
Oh, okay.
Even it is one share, I think it dividend out of it. So I don't hear SBI's matter. I would say all SBI's taxes to other parts. That's so.
Very well.
This matter before the bench in front of us, my name is not a name.
Item number 17.
May I please? Let's first, why Article 30? My answer is that.
Go to the High Court, please. If at all, we are not even going to open that door, but we are not entertaining this. This process has been hanging fire for long enough. All attempts have been made, miscellaneous applications, review petition, everything over.
No issue.
Now what 52?
No.
232, not even one.
Honorable High Court.
OMR data also we are
said that one tainted conduct should be excluded.
OMR
And
data we are
despite that, they are
supposed
doing
to provide to you.
Please give us liberty to.
Sorry. No, we will not say anything. We are not inclined to entertain these petitions.
Let's withdraw it. Yeah, we'll
Having argued for some time, learned senior counsel appearing for the petitioner in both these petitions seeks leave to withdraw both of them. Permission granted, the writ petitions are recorded.
Give us the liberty to go back.
Nothing.
Otherwise,
you said you'll withdraw now. Again, you want to now open a window.
Genuine problem is
sorry.
Elections were given by your lordship.
File a writ petition. You don't need a nudge from the Supreme Court.
No, matter is still pending with your lordship. When it comes to the tainted candidates, that's why they will not interfere. That's why we apprehend to come here.
Not an observation.
We'll go back, we'll go back.
Nothing at all, Mr.
We'll go back.
Next matter, Lord, I am 17.1, my lord. 17.1, but there is a matter.
You don't want to withdraw. I thought we talked about
go back to both. Yeah, my lord, my prayer is very limited.
OMR data, we are not here to provide.
No, I'm not asking from my lord, but my direction is to the CBI.
Do you wish to withdraw it or not?
But I will.
Otherwise, we'll dismiss.
Allow me to go to the High Court, my lord.
No.
Because I need, Lord,
that's liberty we are not.
I need to file a review.
Sorry, we are not opening even a window for you. Leave a door. The door to be open wide for
being flouting your lordship's directions. They're going flouting the direction they
sorry,
of tainted candidates. But that's why we have come here.
All attempts have been made. You're in the long queue of.
I've been still in service. I'm still been in service. I'm untainted. I've been given age.
Whatever it is,
I've been
we are not
protection.
Only we are not opening.
You should not have backdoor
Next matter.
Number 18.
Next matter.
It's against the same issue is pending.
No, but I remember sitting with the Chief Justice. We had dealt with this issue. If I remember correctly, we had decided it also. There must be a judgment on 28/9.
No, that follows on the delay aspect and interpreting the amendment.
We dealt with this. I remember distinctly that we had heard the matter at length on 28/9 and the scope of the unamended and the amended provision.
We'll check it, but a huge batch of.
You must have argued.
No, it's
I mean, your office must have argued. How is it that you would be unaware of it?
That is on canon, my lords.
And all the cases which the High Court relied upon, against all those cases you filed SLP?
Entire batch is pending before.
Let's verify whether we decided it or not.
We will do.
I have a vague idea that we did.
We will do. The entire batch is pending. Over 400 matters are pending.
Then counsel appearing for the petitioner shall ascertain whether issue was decided by this court earlier. And if so, place a copy of this order before us. How much time would be required to verify?
1 week.
Post on 11th August.
Wait.
There's one more matter. Start also.
Wait.
Item number 19.
Look, this is a case of reversal, and I'm requesting notice. May I request the court to take?
Purely a question of fact, Mr. Shantivan, whether this construction was there prior to 1984, whether it
No, not. Can I just tell you what's happened here? There's a reversal, Lords. There's a municipal corporation issued a notice. Just go to page 765. How can the High Court say this? Just go to 765, volume 2.
765.
Volume 2.
Yes.
You have annexed your P30. And I'll show you what the High Court's finding on this. Right?
765.
5. Your Lordships have that?
Yes.
Last so this is the notice under section 351 of the Municipal Corporation Act. And please see the sketch. So the original room is shown and the entire hatched portion.
This is on the basis of some 2009 plan.
No, this is straight on
what the High Court says.
No, this